The world has been seeing with dismay the crime of ethnic cleansing and genocide being committed in Myanmar on members of the Rohingya Muslim community in the western Rakhine state. The end result of this violence has been the entry into Bangladesh of more than 640,000 Rohingya since late August 2017. The large majority of them are women, children, and elderly persons. This latest intrusion has taken the total number of Rohingya who have entered Bangladesh over the last 3 decades to over 1 million. The UN Special Advisor on the Prevention of Genocide Adama Dieng and the Special Advisor on the Responsibility to Protect Citizens Ivan Simonovich have called on Myanmar to address the commission of atrocity crimes that are in motion in Myanmar and also stop discriminatory practices. They have also suggested that those committing crimes tantamount to genocide need to be held accountable despite their status. Some other international social jurists have urged that consideration be given for this subject matter to be referred to the International Criminal Court (ICC). Before moving on, it would be useful to trace some details about the Rome Statute. The purpose of the Roman Statute as it stands today, only 124 states have ratified or acceded to the Rome Statute. Bangladesh signed on September 16, 1999 and ratified and acceded to it on March 23, 2010. Israel, Russia, Sudan, Iran, and the US have signed but not ratified the statute. Non-party members among others include India, Myanmar, China, Pakistan, and Saudi Arabia. Burundi, this October, has informed the relevant authorities that they have decided to quit the International Criminal Court statute paradigm, alleging that it is biased against Africans. There are 3 jurisdictional requirements in the Rome Statute that must be met before a case may begin against an individual or a party. The requirements are 1. Subject matter jurisdiction, what acts constitute crimes; 2. Territorial or personal jurisdiction, where the crimes took place or who committed them; and 3. Temporal jurisdiction, when the crimes were committed. The court's subject matter jurisdiction refers to the crimes for which individuals can be prosecuted as listed in the statute. The primary crimes are mentioned in Article 5 of the statute and defined in later articles: genocide defined in Article 6, crimes against humanity defined in Article 7, and war crimes defined in Article 8. In addition, Article 70 defines offenses against the administration of justice, which are also crimes for which individuals can be prosecuted. Textbook crimes. Article 6 defines the crime of genocide as acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. There are 5 such acts which constitute crimes of genocide under Article 6: a killing members of a group; b. causing serious bodily or mental harm to members of the group; c. deliberately inflicting on the group conditions of life calculated to bring about its physical destruction; d. imposing measures intended to prevent births within the group; and e. forcibly transferring children of the group to another group. The definition of these crimes is identical to those contained within the Convention on the Prevention and Punishment of the Crime of Genocide of 1948. Article 7 defines crimes against humanity as acts committed as part of a widespread or systematic attack directed against any civilian population, with knowledge of the attack. It is clear that there are criminal ramifications pertaining to the current Rohingya situation. The article lists 16 such as individual crimes: murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment, or other severe deprivation of physical liberty, torture, rape, UAL. Slavery, enforced prostitution, forced pregnancy, enforced sterilization, UAL, violence, persecution, enforced disappearance of persons, apartheid, and any other act that may be adjudged by the court as inhumane. Article 8 defines war crimes depending on whether an armed conflict is either international or non-international. In total, there are 74 war crimes listed in Article 8. Grave breaches of the Geneva Conventions include armed conflicts leading to willful killing, torture, inhumane treatment, biological experiments, willy causing great suffering, destruction, and appropriation of property. Other crimes include serious violations of Article 3 of the Geneva Conventions that include murder, mutilation, torture, and outrages upon personal dignity. Article 70 criminalizes certain intentional acts which interfere with investigations and proceedings before the court, including giving false testimony, presenting false evidence, corruptly influencing a witness or official of the court, retaliating against an official of the court, and soliciting or accepting bribes as an official of the court. The territorial jurisdiction of the court includes the territory, registered vessels, and registered aircraft of states which have either 1. become party to the Rome Statute or 2. accepted the court's jurisdiction by filing a declaration with the court. For reaching jurisdiction in situations that are referred to the court by the UN Security Council, the territorial jurisdiction is defined by the Security Council, which may be more expansive than the court's normal territorial jurisdiction. For example, if the Security Council refers a situation that took place in the territory of a state that has both not become party to the Rome Statute and not lodged a declaration with the court will still be able to prosecute crimes that occurred within that state. The personal jurisdiction of the court extends to all persons who commit crimes, regardless of where they are located or where the crimes were committed, as long as those individuals are nationals of either one states that are party to the Rome Statute or two states that have accepted the court's jurisdiction by filing a declaration with the court. As with territorial jurisdiction, the personal jurisdiction can be expanded by the Security Council if it refers a situation to the court. No statute of limitations applies to any of the crimes defined in the statute. As universally agreed and followed, the Rome Statute provides that all persons are presumed innocent until proven guilty beyond reasonable doubt and establishes certain rights of the accused during investigations. Victims before the International Criminal Court can also claim reparations under Article 75 of the Rome Statute. Reparations can, however, only be claimed when a defendant is convicted and at the discretion of the court's judges. Reparations can include compensation, restitution, and rehabilitation. The Srebrenica debacle in Bosnia during the 1990s has also underlined that it would be incorrect of non-party states to think that cooperation on their part with the International Criminal Court can only be of a voluntary nature. It was clearly decided, at that time, that even states that have not acceded to the Rome Statute are obliged to cooperate with ICC, if a case is referred to the ICC by the UN Security Council. In such a situation, all UN member states are obliged to cooperate, not only because its decisions are the binding for all of them, but also because there is the international obligation to abide by and ensure respect for international humanitarian law as contained in the Geneva Conventions and Additional Protocol I. It is clear that there are criminal ramifications pertaining to the current Rohingya situation. Consequently, the government should make up its mind. Subsequent measures will require coordination at different levels. Mohammed Zamir, a former ambassador and chief information commissioner of the Information Commission, is an analyst specialized in foreign affairs, right to information, and good governance. He can be reached at email protected.